Welcome. My name is Olajide Olagunju, and I'm the author of the book, How to Resolve Conflict. That's the book right there in front of you. We have been doing a series of a lecture series around this book, and we are continuing today our daily lecture titled How to Resolve a Conflict. We have discussed chapters 1 to 3, and now we are going to chapter 4. I welcome you. I invite you to make your contribution as we go along. Thank you for joining me. Chapter 4. The title of chapter 4 is When Mediation Works. When Mediation Works. And it begins with a quote. We do not, for love of beef, defer to the cow, unquote. We do not, for love of beef, defer to the cow. That's another Yoruba adage, or shall I say proverb. And it speaks, I think, to this chapter's title, When Mediation Works. And we'll see how the adage or proverb is relevant as we go along. Let's read from chapter 4. In my mediation practice, I have seen parties react positively to the process of mediation. They take risks. They take risks with the other side and voluntarily and trustfully make admissions that years of an adversarial approach would never have wrung out of them. They go the extra mile to meet both their needs and those of the other party, and accept a lot of sacrifices in order to reach a settlement. So what am I saying there? I'm saying that when people are operating or resolving their conflict in an amicable forum, such as mediation, they act more trustfully. They tend to trust each other more than when they are in an adversarial forum, such as litigation, such as arbitration, where they have to be told they are right or wrong, where they have to be made losers or winners, where they lose or win based on best performance or otherwise. And so they're in an adversarial situation. They are at war, as it were. And so they are dealing with the other party on tiptoes. They are very, very, very careful, very sensitive, very conscious, because they have to win, otherwise they lose. And they could win just because they are very good actors. not because they are right. uh, and so they are not ready to accept. Of course, they're not ready to accept defeat, but more important, they're not ready to consider the other side's view, because the other side is an enemy, pure and simple. That's the adversarial forum of the court or arbitration. So, because somebody has to, in those adversarial fora, somebody has to win, somebody has to lose. And losing may mean having damages awarded against you that is phenomenal. There's a recent case between a government, a country, and a company when their agreements, their contract ran into some challenges, and the country lost at arbitration, and the arbitrators awarded amazing costs and more importantly, damages. You know, they quantify the damages in a way that that was challenging. I can't imagine if I'm an arbitrator too. I can't imagine making that kind of award. It was extreme. They awarded the party that won. They awarded them damages calculated based on what the arbitrators considered to be what they would have lost if the business had not collapsed, what they would have lost in, say, I think 20 years. I've forgotten the exact figure I wanted, but I believe it ran into billions of pounds sterling. Well, they're in court. Trying to sort out whether or not they should pay or should not pay, whether or not there was fraud involved in the party that won, bringing the arbitration, or whether they were not fraudulent in going to the contract in the first place. Of course, it was a split arbitration, but 2 out of the 3 arbitrators gave the award I just spoke about, and the officials of the country, public servants, said, if we have to pay this money, that's our. What did they say? I believe they said it was the whole budget for a year. So the country would run into difficulty. If they had to pay this, but they didn't have to go to an adversarial fora, really, even though the agreement they signed said they had to go to arbitration. But we know that in even in the country's Arbitration and Conciliation Act, there's a provision that you are at liberty to try an amicable forum, even if you had agreed to, even if you had agreed to do arbitration. They could have gone to mediation, gone to conciliation, try to negotiate amicably. Unfortunately, that doesn't seem to have been the case. And so they ended up with this very challenging situation that it appears the British courts themselves that have to implement the arbitration are having difficulties. But this is because I believe this is largely because they approach their conflict from an adversarial perspective. They failed, refused, or neglected to use an amicable mechanism. I think we can stop there for today and then continue tomorrow. Our discussion around chapter 4, titled When Mediation Works. In this book, the textbook for this lecture series, which itself is titled How to Resolve a Conflict. Thank you for joining me. Again, I invite you to please post your comments as we go along and share this lecture series. It's free. And also, consider getting a copy of the book. It's free on Kindle. And you could also get it for a token from get a soft copy for a token, as well as you can also get the hard copy. All three are available on Amazon. So we'll see you tomorrow as we continue this lecture series on how to resolve a conflict. This is lecture 13 we've just had. Tomorrow we'll have lecture 14. Thank you so much.